In a big win for AR Rahman, the Delhi High Court this week set aside a copyright infringement case against him where he was directed to pay rupees 2 crore in damages for a song that he had composed for the Mani Ratnam film Ponniyin Selvan 2. Hello and welcome to The Print. In this video, I will be breaking down what this case was about and why exactly the Delhi High Court set aside or quashed the April 25th ruling which found Rahman's song to not just be inspired but in fact identical to the Dagar brothers' composition Shiva Stuti. Now in April this year, it wasn't just AR Rahman but also the film's producers who were directed to deposit a sum of rupees 2 crores by a single judge bench of the Delhi High Court. However, the new ruling, which has been passed by a two-judge bench of the High Court, has now set aside the earlier order which found Rahman's song identical to that of the late Junior Dagar brothers. The heart of this case was a song titled Veera Raja Veera, which was essentially a classical composition performed by the late musician duo Junior Dagar brothers. Now this week, in its 93-page judgment, Justices C. Harishankar and Om Prakash Shukla observed that the case was not an ordinarily couched litigation relating to the infringement of copyright in musical works. Instead, it involved the intricate task of applying modern copyright principles to traditional heritage art forms like Indian classical music, which have evolved collectively over centuries and for which the privilege of copyright protection may not be available. The controversy erupted over the ownership of a song in the 2023 Mani Ratnam film Ponniyin Selvan 2 titled Veera Raja Veera when a classical musician and Padma Shri awardee Ustad Fayaz Wasifuddin Dagar approached the court in October 2023 saying he was an exponent of the Dagarvani style of Dhrupad classical music and that the song was copied from his father and uncle's composition Shiva Stuti. The father-uncle duo were famously known as the Junior Dagar brothers and included the late Ustads Fayazuddin Dagar and Zahiruddin Dagar. However, in the recent ruling, the court rejected the musician's claim over Shiva Stuti, saying that there was no evidence that the late Dagar brothers were the authors of this composition. In doing so, the court differed between performers of a copyrighted work and authors of a copyrighted work, while pointing out that a performer does not become the author or owner of a copyright in a song simply by performing it. Outlining the differences between the performance of a work and authoring it, the court said that although there was evidence of the Dagar brothers performing the composition at the Royal Tropical Institute in Amsterdam in June 1978, it could not be said that they were the original authors of the same. Interestingly, the court also explained the concept of the Guru-Shishya Parampara, which is found in the learning of Indian classical music, while adding that in this tradition, the Shishya or the disciple imitates the Guru or the teacher, and the composition is evolved and passed through various ages and generations, oftentimes orally. In this system, neither any guru nor shishya nor any single artist can claim absolute ownership over a particular composition or a raga or a musical motif, the court said, while acknowledging the irony that this concept was fundamentally at odds with the prevailing copyright law, which assumes a clearly identifiable creator and a fixed form of expression for copyright protection. Taking a look at the Dagar brothers' 1996 album, Shiva Mahadeva, the court noted that the album did not credit the brothers as copyright holders or authors of the Shiva Stuti composition. This suggests that even the album producers treated the work as traditional or a common work of performance and not as an original composition of the Junior Dagar brothers, the court said. Recalling that in ancient India, creative persons like musicians and writers composed and authored for name, fame and recognition as opposed to simply commercializing their works, the court also went on to say that back then there was no concept of copyright. With the advent of science and technology and the printing press, however, copyright disputes became inevitable, it said. The fundamental question in this case became that of ownership of the composition, causing the court to say that it's a core part of copyright laws as the initial enforceable rights over a creative work are granted only to the author. Now let us also understand what a copyright means in law. A copyright is a right given by the law to creators of literary, dramatic, musical and artistic works, and also producers of cinematographic films and sound recordings. Simply put, it is a bundle of rights including the right of reproduction, communication to the public, adaptation and translation of the work. The 1957 Copyrights Act seeks to protect such creative works which are deemed to be the creator's intellectual property from unlawful or unauthorized use. The court also noted that practical enforcement of copyright laws, especially in genres like Indian classical music, where works are transmitted orally, can be a difficult job, while adding that the Shiva Stuti was a perfect example of these challenges, as its authorship is tied to its first performance and the oral tradition rather than a formal written composition. Significantly, Rahman argued that granting protection to the classical musical composition in this case would promote a monopoly, adversely affecting the artists and composers of Hindustani classical music and also Carnatic music. Rahman argued that the basis for Dagar's claim was an alleged oral family settlement of 1994 supported by a letter signed by 3 individuals, while ignoring other Dagar family members who had also performed Shiva Stuti in a similar form. For these reasons, the court allowed Rahman's challenge to the April order and gave him the needed relief. That's all for today. For more legal updates, stay tuned to The Print.